It is now 10 o'clock and we'll go ahead and get started. Good morning, everyone. I am Aaron Blumberg. I'm Swiftland's Continuing Education Coordinator, and it is my pleasure to welcome you to this morning's webinar, Copyright and Fair Use for Libraries. We have a wonderful learning opportunity ready for you this morning with Michael Rodriguez. Michael Rodriguez is the e-learning librarian at Hodges University. He manages all digital library services and resources as well as teaching information literacy. Michael also blogs and runs social media for the Library and Information Technology Association, LITA. Please welcome Michael and enjoy his webinar this morning. Michael?
Good morning, everyone, and thank you very much for coming to this Swiftland webinar on copyright and fair use for libraries. As Aaron indicated, my name is Michael Rodriguez. I'm the e-learning librarian at Hodges University, and in my spare time, I also volunteer as social media manager for the National Library and Information Technology Association. Now, in both those capacities, I deal with copyright issues on a daily basis. As e-learning librarian, I am tasked with managing the contracts and digital licensing agreements and access issues for our electronic resources and databases. And as you can imagine, that can get complicated. As social media manager, I use a lot of images in my Twitter and Facebook posts for LITA, and therefore I make sure to use images that are in keeping with copyright restrictions, meaning that they're openly licensed or I have permission to use them. So that's my job. How I got into copyright is a little bit different. I'm fascinated by copyright for several reasons. And the main one is that for me, copyright is the great gray zone of librarianship. It is where our professional values of opening access to information for everyone can sometimes come into conflict with our legal obligations to comply with the law, and also with everyone's ethical responsibility to ensure that authors and creators get rewarded and recognized for their work. So what I'm hoping to do in this webinar is not only give you an overview of copyright and take you through the various variations and permutations of copyright, take you through a fair use analysis, and explain the various exceptions and regulations that libraries and educational institutions and archives are subjected to, but also to show you ways in which to push forward the boundaries of copyright to reduce unnecessary restrictions while ensuring that recognition and reward for authors. So that's my twofold goal for today. My information is on the PowerPoint, and that will be posted to Swiftland's website after the session, so you can always feel free to get in touch with me at any time. For housekeeping announcements, I am hoping to leave 10 minutes for questions at the end. If you have any questions along the way, feel free to pop them in the chat box, and I'll get to them as soon as I finish my current train of thought, which is usually at the end of each slide. A disclaimer, I am not a lawyer. This is not legal advice. If you have a specific legal question that needs resolution, I have to advise you to consult your campus attorney or your county attorney. That said, I'm more than happy to sit down with you via email or phone and help you work through any specific questions or copyright issues that you may have now or at a later date. Okay, let's move on. What is copyright? I'm going to switch off my webcam for a minute now. So what is copyright? There's a lot of confusion about that. And what I would like for you guys to do is, if you will, put in the chat box a word or a short phrase or anything that comes to mind when you see this question, what is copyright? Or when you think of copyright. And I'll give you a few minutes for that. Okay, so Marilyn says money or dollar signs. Excellent. Yes. A lot of copyright does boil down to who gets the money as a result of the work, whether that's the author or whether that's the publisher or the corporation that owns the license to the work. Protection of authors' creative rights. Yes, that and money are the two big things. Excellent. Thank you, Amanda. Balance between authors and users. Yes, fantastic. That is um, that is the goal of copyright ultimately, and it's definitely a work in progress. Let's put it that way. Public domain. We'll have a whole section devoted to that, Angela. Good one. Um, Kelly, restricting protection. I like that because in that phrase you're combining protecting the work and the authors with restricting the work at the same time. And it's true, those two are not necessarily incompatible with each other. And we'll look into that. Nancy, promoting creativity while protecting authors' creations. Yes, that is the ideal implementation of copyright. Yep. Jack, author's choice is essential. And Susan, public domain. Good one, Justin. Brian, yes, absolutely. It does restrict the information that we can distribute to patrons, electronically in particular. Looks like we have a raised hand. Do you have a question? Okay, it looks like A. Sullivan might have a question, but I don't hear any. Let's see. You can go ahead and type in the chat box if your mic isn't live. Disney's stranglehold on creativity. Yes, we'll be talking about that, Eric. So this is great. You guys actually have a really good understanding going in of the complications and the goals of copyright. I love this. So let's take a look at what copyright consists of. And this is the legal definition of copyright. It's taken from the U.S. Constitution and from various government docs, and I reshuffled some of the wording to get it all in one sentence. So it is the exclusive legal right to reproduce, distribute, modify, and perform original works of authorship fixed in a tangible medium of expression. And the yellow asterisk at the end is my addition, meaning exceptions apply. So let's break this down a bit. Exclusive legal right. So this is a legal obligation and a legal right. It's not an ethical issue like plagiarism, when you might copy somebody's ideas into a paper for school and without giving them credit. This is a legal obligation and right that is enforced by potentially by significant civil penalties. And it is exclusive to the author or to whomever the author decides to assign rights. To reproduce essentially means to copy. Distribute means to share, to post on the web, to make copies and hand out in a public place, etc. Modify means to change, alter, or adapt the work for your own uses. So, for example, kind of like what I did with the US Constitution just now. And perform. That can refer to public performance of music or screening of films. Original works of authorship. And this is a key phrase because an original work of authorship has to be, exactly, Nancy, music. Original works of authorship have to be, require some kind of human, unique, creative input to produce. So in other words, I cannot claim copyright over a rock I found because I did not create that. And in fact, there was a legal case recently in which a photographer handed a monkey a camera, and the monkey took a picture with the camera, a really hilarious selfie. And But the photographer, it turned out he didn't actually have the rights to that photo, even though he owned the camera, because the monkey took it. And the monkey is not a human being and does not fall under copyright. And also, the work has to be in a fixed and tangible medium of expression. And this is actually a lot broader than it sounds. Fixed and tangible could be a video recorded dance performance, a music recording, a web page, or that old traditional printed book. So the goal of copyright, as you guys indicated earlier, is it really is originally intended to protect authors from having their work stolen and having that work sold and other people making a profit without the authors getting any fees in return. So this quote comes from the U.S. Constitution, Article 1, Section 8, Clause 8, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So there's some interesting things we can break down in this sentence. First, it seems to be talking about scientific work and about artistic work, useful artistic work like craftsmanship, rather than creative literary works, which is unexpected perhaps. But the key thing I wanted to point out is securing for limited times. So really what qualifies for limited times? Remember, the Constitution, this clause was created in 1789, I believe, and the concept of copyright as a protective regulation for authors goes back to England in the late 1600s, early 1700s. So what do we mean by limited times? Oh, am I breaking up? Can everyone hear me okay? Ah, excellent, thank you. So does anyone know how long copyright exists right now in the 21st century? Yep, nail on. That was, let's scroll up and see the chat. Oh, Nancy and Brian, you pretty much hit it on the head. So, and yes, excellent point, Eric. It varies by country. So in the United States, copyright has varied a lot. As written by Thomas Jefferson into the Constitution, the original term of copyright was only 14 years from the date published. Um, and that lasted until 1909 when copyright law changed, and copyright became a 28-year deal with the option for the author to renew for another 28 years. But after 1978, when a Copyright Act was passed, it became life of the author plus 70 years. So if the author lived for 50 years following the publication of the work, we could be looking at a period of 120 years before the work enters the public domain and anyone can have access to it. For works made for hire, so if you were contracted to produce a paper or a piece of art, or for works created anonymously, the duration of copyright is actually 95 years from first publication or 120 years from the creation of the work. And as you can imagine, this is the author is long dead at this point, of course, and typically the estate may not even be collecting revenues at this point. So many of these changes were motivated more by the publishing industry, the music industry, and so on. Yep, Sonny Bono, yes indeed. Rather than by a desire to ensure that authors get the credit and rewards they deserve. Exactly, Brian. That's an excellent point because um, it depends in that case on how original the expression is. So I actually want to come back to that because that's an excellent point. So Yule Pop quiz here. This one is pretty obvious. Because most libraries are nonprofit or government agencies, copyright regulations usually don't apply to us. That is definitely false. Copyright regulations do indeed apply to us. So you can go ahead and type in the chat box if you like, T for true or F for false. I cannot be held personally liable if I infringe copyright while on the job. Boom. False. Yes. In fact, if the copyrights holder does decide to hold the institution liable to impose civil penalties through the courts, um, they can sue both the individual who infringed and the institution that employed that individual. And the civil penalties, the statutory damages alone could be up to $150,000 per infringement. Next question. Anything without a copyright notice is not protected under copyright law. True or false? It is quite a lot of money, Nancy. Excellent. Fantastic. False. Yes. And this is a common assumption that will also play into the next question. The law allows me to reuse and share online images and articles freely. Very much false. There's a common assumption, especially among folks of my generation, that that anything on the internet is in the public domain and anyone can use it freely, which is most certainly not the case. Anything created by a human being, once it is in that fixed and tangible form, be it a web page or a photograph, digital or otherwise, is automatically copyrighted. And you need to get permission or apply a fair use criteria in order to reuse that. So last one, copyright does not protect ideas. True or false? Very true. Mm-hmm. So copyright protects expressions, not ideas. So you're welcome to take someone's concept, someone's scientific method, someone's theory, and adapt that to your own needs. But you cannot take their actual expressions, their unique content, and reuse it. And it does depend. That going back to your point, Brian. So generally doesn't. Copyright generally protects expressions rather than ideas. And let me scroll back up to your original comment somewhere. Ooh, a lot of falses. So if the author creates a work using public information and manages to make that work truly unique and not something that anyone else could duplicate simply by curating the same information, that probably would be protected by copyright because it's something that took that author's unique um, creativity and insights to implement. But if it's just a curated list of genealogical resources or of names or of locations, that kind of thing, then probably would not be copyrighted. That might be in the public domain. Which goes to our next question. What is covered by copyright? So remember we said original works of authorship fixed in a tangible medium of expression. That can be images, books, articles, websites, blog posts, papers written for classes, class projects. This PowerPoint is copyrighted by myself, even though the images in it are copyrighted by other folks. But because I put them in a unique arrangement and because I changed the context of the images, and often because I comment on some of the images, um, it is a unique work. So, what is not covered by copyright? Coca-Cola is not copyrighted. Names and titles are not copyrighted. Short phrases, slogans, logos, and also lists of ingredients. Interestingly, lists of ingredients for recipes are actually not copyrighted. However, the recipe itself can be copyrighted. Again, if there's some kind of unique creative input in producing that recipe. Whereas a list of ingredients is just objective facts. I mean, you can't really copyright facts. And you can't copyright names or titles either. I can't sue someone for being an e-learning librarian, and any number of parents could name their kids Memphis Eve Sunny Day Hewson, and there's no way that Bono could file a lawsuit claiming intellectual property rights over his daughter's name. However, you can protect slogans, logos, and even some names. You can't do it through copyright, though. You have to file a patent or a trademark with the US government. So if you want to protect your Better Mousetrap, then you'll have to file a patent for it, but you won't be protected under copyright regulations. So the public domain, and this is a public domain photograph of a national park. And you don't have to cite public domain photos. And you don't have to get permission or pay royalties to use them. So it's public intellectual property, essentially. So after a certain number of years, works revert into the public domain, and at that point, anyone is free to copy, use, adapt, and share without infringing on the author's turf or on the publisher's turf. This is kind of a traditional safety valve of copyright, making sure it doesn't last forever. So what works are in the public domain? Non-copyrighted works, first and foremost. And those are works that typically copyright has expired. So the author has died 70 years ago, and therefore the work becomes part of the public domain. Also, U.S. federal government works are automatically in the public domain. It does vary a bit according to state governments, but most of those are also in the public domain. Pre-1923 works are almost universally in the public domain. So, and this includes a lot of the short films, a lot of classic novels, and so on. It's why you can go onto Project Gutenberg and download any book published prior to 1923 free of charge. The cool thing is, too, that you can actually dedicate works to the public domain. You can release your photograph, for example, under a public domain license. So right away, you're contributing to this knowledge commons globally. Nancy, that's actually a really good question and a fairly complicated one, too. Oftentimes, you really have to dig to find out whether a work is copyrighted or not. Because between 1923 and the 1970s, there's a lot of works that folks copyrighted initially but did not renew, and therefore the copyright expired and it went to public domain. So, for example, the film Night of the Living Dead, which started the zombie craze way back in the 60s, I think, film is actually now in the public domain because George Romero, the director, forgot to renew the copyright license. And there's some weird issues too. It's a Wonderful Life. Everyone knows that film. It's interesting because the copyright, the film itself is in the public domain now. The copyright expired because it wasn't renewed. But the music and the script are still under copyright. So you can't really publicly perform the film or screen it without getting permissions, even though the footage itself is in the public domain. It's one of those really weird, fascinating twists of copyright. So here's another example. Does anyone recognize the painting on this old postcard, with or without the mustache? Mona Lisa. Good job, Laura and Nancy. Um, so this is the original Mona Lisa, painted by Leonardo da Vinci in, I want to say, very early 1500s. So clearly it's in the public domain. However, in 1919, Marcel Duchamp, a French Dada artist, who actually, who I think Salvador Dali did definitely take after in terms of surreal art, Marcel Duchamp essentially took a copy of Mona Lisa and drew a mustache and a goatee on it and called it an original creative work, which it is. And that picture is copyrighted because Marcel Duchamp changed the original public domain image and kind of created a humorous parody of the original venerated Renaissance artwork. However, it was created in 1919. So in the United States, this painting by Marcel Duchamp, or this sketch, sorry, is in the public domain, so anyone can use it and freely. The twist comes is that in France, the source country and the homeland of Marcel Duchamp, this piece of art is still copyrighted until 2039. That's why when you're posting information and images and so on the web, you have to be aware that you're posting it to the world. That and while the laws in the United States do apply far more strongly than laws in France or Germany, you do kind of have to be aware of the different permutations in international copyright. For example, I found this picture on Wikipedia, the English Wikipedia, which goes by the United States copyright standards, but it included a disclaimer at the bottom of the photo saying that this picture cannot be added to Wikimedia Commons, which is more of that, more of a global resource perhaps, until the copyright expires in the home country. So there's fascinating twists to copyright, and international differences is just one of them. And let's not even talk too much about orphan works. This pertains mostly to archives and museums and special collections. When they have a photograph, for example, in their collection, but there's no name on the photograph, and nobody knows who to contact in order to get permission to post it. So the photograph is still under copyright, but nobody knows who the author is. So the copyright status is really ambiguous, and there's a lot of concerns there about inadvertently digitizing something and posting it to the web only for the copyright holder to show up and demand it be taken down or attempt a lawsuit. And there's been several court cases regarding orphan works lately, which I'm more than delighted to discuss with you at a later date. But I think orphan works are really helpful just in terms of understanding how complicated and how ambiguous and uncertain copyright can sometimes be. The uncertainty is really typical of copyright scenarios that I have been called upon to review and advise for faculty at my institution. So whenever faculty or my librarian colleagues consult me about a copyright scenario, so can I copy this? Can I post this? Can I download this? My initial response is always, it depends. Tell me more. Context is really the heart of copyright. How is the work going to be used? Are you changing it? Are you putting it on the open web? Are you putting it in a closed, password-protected intranet? There's so many factors to consider that really each scenario has to be judged independently using the 4 factors of fair use. So this is another safety valve of copyright along with the public domain. The 4 factors of fair use are on the screen, and I actually typed all these out. Usually I am reluctant to put much text on my slides because of death by PowerPoint, but this is key information. So the first factor of fair use, whenever you're making a call about whether to use a copyrighted work, the first factor you have to think about is the purpose and character of the use you're claiming is fair. And this is the factor that the courts have upheld as the most important factor. So if you are copying or distributing or modifying a work for educational uses, then you're on much firmer ground than if you were copying a work and then using it in an advertisement to drum up sales for your company, for example. And this is actually where for-profit libraries run into trouble, because the law specifically states that libraries and universities have to be educational institutions and nonprofit. So for-profit libraries operate in more of a for-profit libraries at for-profit universities operate in a bit of a gray zone when it comes to copyright and fair use. So they need to be extra careful when applying these criteria. The most common use of fair use other than educational is for criticism or commentary. So it's okay in a book review to pull a paragraph from the book and talk about the paragraph, critique it, its style, its content. It's okay to reproduce a low resolution image, um, copyrighted image in an encyclopedia article or a blog post, as long as you're commenting on or critiquing or evaluating or analyzing that image. You can also make changes to the work if the changes result in a parody of the original, in a humorous twist that changes the meaning of the work. So, for example, going back to Mona Lisa, this would qualify as a parody. And we'll be looking at a couple of others in a minute. It might also qualify as a transformative use, and this is a phrase that is used a lot by the courts and by copyright lawyers. And that refers to when you take the original work and the modifications you make to that work change the meaning, change the appearance, and make the work into something new, essentially. Even though even though it's based on an original that you copied. The second factor of fair use is the nature of the copied work. And this is interesting because going back to our Constitution slide, we'll do that really quick. To promote the progress of science and useful arts. So this copyright actually has shifted from that and is now primarily dedicated to protecting more creative works rather than nonfiction or primarily factual works. So this is certainly not always the case, but it does tend to be. If you copy someone's novel, you're more likely to get a major lawsuit than if you copied someone's scholarly journal article without permission. If someone posts Harry Potter for free on the internet, they'll probably get taken down. If they post my history journal article that 10 people read on the internet for free without telling me, I probably won't notice. And I doubt it would be taken down. The third factor of fair use is the amount and substantiality of the portion used. So the rule of thumb here is if you are copying a work, then you should probably copy under 10% of the total work, or one chapter of a book, whichever comes first, or one article from a journal issue, that kind of thing. This is, again, though, you have to apply it on a case-by-case basis, because if the work you're copying is the heart of the work, then we're looking at something different. If the work you're copying really captures the significance of the work, then you could still be subject to legal issues. There was a problem back in 1985, actually, when the Nation printed 400 words from Gerald Ford's autobiography, and they were extremely, and these words really were the heart of the work. I forget what they were, but they kind of captured the significance of Gerald Ford's publication. And so the publisher of the biography, Harper and Row, successfully sued the nation, claiming that they infringed on copyright because they copied the heart of the work. Kind of, yeah, Nancy. Hmm. And that also relates to the effective use on the potential market for the work. So if people are not going to buy Gerald Ford's biography because they already got the key information they wanted from the excerpt printed in the Nation, then that could reduce sales and profits for the publisher as well as for former President Ford. So let's run through a couple of scenarios. So probably a lot of you will recognize this photo from 2009. It was an Associated Press photo of President Obama shortly after his election, or actually shortly before his election, I think. And it was taken by an Associated Press photographer, so AP has copyright over the original photo on the left. What an artist named Shepard Fairey did was take the original photo and go into Photoshop and add different coloring and filtering and the word hope and market that photo as a poster that he sold and that Barack Obama's campaign was actually enthusiastic about. Well, Associated Press sued the artist for infringing copyright. He didn't get permission for the original photo, and he was making money off the modification he did. And the artist settled out of court after the judge warned him that he would lose if the case went to trial. And this scenario we're looking at would qualify as a derivative work. So this is a work that essentially takes the same image, it's recognizably the same picture, same expression, similar feelings imparted to the viewer, and just makes minor modifications that don't really fundamentally create a new work. I would personally argue that this is a little bit more of a transformative use, but the courts apparently considered otherwise. So the next image I want to show you is also an image of our president. And the image is much more controversial and problematic for a whole bunch of reasons, only some of which have to do with copyright. So this is that famous photo of the president as the Joker in Batman. The original image is taken from a Time magazine cover photo, which you see on the far left. In the center is a modification of that original photo that was created by a bored Palestinian-American college student in Chicago in 2009. He downloaded I guess he took a screenshot or something of the Time magazine cover, and then he went into Photoshop and modified the president's face to resemble the Joker. And he did that just because he was bored, apparently. He was actually tended to be apolitical rather than opposed to the president's policies. But he posted it to Flickr, the image sharing service. And somebody else came in and took that image, removed the background, added the word socialism, and started putting flyers of it all over Los Angeles. Flickr got wind of it and found the original photo and removed it because claiming that the modified image infringed on the original photographer's rights. It's worth noting that Time magazine never actually filed a complaint about the student's use of their cover photo. And Flickr actually had to modify its takedown policy as a result of some outcry, because this image is not derivative so much as it is transformative. The whole meaning of the image has changed as a result of its modification. It has a lot of political implications, most definitely, and one would argue that it is protected not only as transformative use, but as free speech, despite the extreme and troubling image it presents. And you can actually find the original modified Time magazine photo. It's back up on Flickr. So these are kind of examples of how not only authors and users, but companies themselves find themselves in copyright areas where they're not really sure what to do and they can make mistakes. Blurred lines. How many people have heard of that copyright lawsuit? Zada. Mm-hmm. Ah, Nancy's heard of it. Oh my gosh. Okay, so we're about 50-50. Excellent. So, in case you don't know, Blurred Lines is a pop music song by Pharrell Williams and Robin Thicke. And I'm actually not particularly fond of the song, but it's a good example of the complications involved in music copyright. Because Williams and Thicke actually borrowed a lot of the of the music, not the lyrics, but the music itself, from a Marvin Gaye song called "Got to Give It Up," which I actually love. And in fact, doing some research for today's session, I ended up going on a Marvin Gaye kick, which was a lot of fun. So Marvin Gaye's family sued the producers and singers of Blurred Lines. And just last month, a jury awarded the family $7.4 million. And the main reason for this is that maybe not it was a transformative use of the music. The lyrics are certainly different. But Pharrell Williams and Robin Thicke made money off this song, a lot of money. And that definitely flew in the face of the fourth factor of fair use, which, if as you recall, was the effect on the potential market. Lots of money. Exactly, Amanda. So, nature of the copied work. We kind of took a look at this already. Copyright regulations tend to be a little bit less strict with factual nonfiction type works than with fiction, because facts and interpretations of those facts tend to be they're seen more as something that is in the public's interests. It's for the public good, as opposed to more creative works, or literary works, which are more perhaps more unique to the author and more for entertainment purposes. So music is very heavily restricted because it is one of the most quintessentially creative works, unless you copy a Marvin Gaye song. As far as the amount of substantiality of the portion taken, um, we talked about the 10% or one chapter of a book, whichever comes first. And for this, it really does depend a lot on what you're copying and how you're using it. We'll take a look at a couple of other scenarios related to libraries so shortly. And market impact. Oh gosh, I love this slide. Anyone remember the fuss about Left Shark and Katy Perry's Super Bowl performance? Is that a nose? He does, Justin. Yes. So this is actually a. Oh wow, a lot of people knew. Cool. Katy Perry is popular in the library world. So what this is about, Katy Perry performed at the Super Bowl, and she had two backup dancers who were wearing shark costumes. And Left Shark was kind of a funky shark, and he instantly became internet sensation. And this guy, Fernando Sosa, actually designed a 3D printed design for 3D printing and posted it for free on MakerBot Thingiverse. Oh man. um, so anyone could download it. The problem was Katy Perry's attorneys and so on wanted to capitalize on the unexpected popularity of Left Shark, so they sent a cease and desist order to remove the digital design from Thingiverse, even though typically costumes are not copyrightable. The lawyers claimed that the drawings and the designs for the costume were under copyright, which is a bit specious. And they even attempted to trademark the Left Shark design, and I'm happy to report that the US Trademark Office just denied the application. So I would definitely encourage Swiftland to create lots of Left Sharks and hand them out at Library Staff Day to support open use. I couldn't resist, Lily. And they are rather cute, I have to admit. Okay, so exceptions for libraries. There are gaps purposefully left in copyright regulations for libraries and for archives and museums and other public service organizations that have to deal with information. One of the big ones is the first sale doctrine. And this is the safety valve of copyright that enables libraries to have used book sales, that enables us to lend out books to our patrons without charging them and without paying the publisher fees. It enables us to throw away books, to make art from books, to put books on display, to accept donations. It is essentially, once you buy or otherwise obtain a legal copy of a book, a print book, then it's yours to do with whatever you will. This does not apply, however, to ebooks, and we'll be talking about that in a minute. So, by the way, as far as those publisher preprints that you get sent and that say in big font, do not sell, not for sale, discard after reading, I get a few myself because I review books for Library Journal. Ignore those written restrictions because once you legally obtain a copy, once the publisher sends you a copy, then it really is yours and you can sell them or loan them or whatever you need to do. You probably should wait until you get the final copy, but first sale doctrine trumps publisher claims. Okay, so educational use exceptions. Right, Nancy, and ebooks they're a whole other kettle of fish, and I could talk for probably 20 minutes about ebooks alone, but we do have a slide later, so I'll probably talk for 5 minutes. So educational use exemptions, there are a lot of those, fortunately. So your students in the classroom can feel free to use images from the internet, can feel free to create collages from the internet. As long as they don't post those collages or video pastiches or whatever on the open web. At that point, then you have to start applying some fair use analysis. Also, for teachers and faculty in the physical classrooms on campuses, you can show films, you can play music, you can reenact plays, you can distribute copies of readings, and there are not too many restrictions about that as long as you're in the physical classroom. Problem is, the law still hasn't really caught up to the explosion in online education and the distance learning environment. So the restrictions there are quite different and more restrictive. The TEACH Act was passed in 2002 by Congress, and it's a step in the right direction. But here again, we're limiting the more relaxed regulations of the TEACH Act to government bodies or accredited nonprofit educational institutions. So libraries at for-profit universities, again, could run into more issues under the TEACH Act. The key thing about the TEACH Act is that it requires that digital content for the class uploaded to Blackboard or Canvas or another learning management system. Copyrighted content distributed to a class online has to be shared in a closed, password-protected environment that is accessible only to students in that particular class. And even then, fair use often still applies. So you're probably not allowed, actually scratch probably, you're not allowed to post an entire book in PDF form, an entire copyrighted book onto Blackboard, even if it is only accessible to students in the class, because you're removing the potential market for that book. If it's a required reading, then students won't have to go out and buy it, and the publisher is going to lose money. You're also not allowed to rip a DVD that you own and post it onto Blackboard. You're not allowed to, this isn't a copyright issue so much as a licensing issue, but even in the physical classroom, you're not technically allowed to stream a Netflix movie for your class because Netflix films are licensed for personal use only, meaning that you really have to be at home or with just a handful of friends, and it can't be in any way, shape, or form a public performance. Certainly, there are ways to get around this. What I encourage faculty to do is link out to copyrighted materials. So rather than uploading an entire ebook or article or copying a website or a video into the learning management system, put a link in. Link out to YouTube. Link out to a library database. Link out to a films on demand streaming site. Linking is pretty much always acceptable under copyright regulations because you're not copying or distributing the actual work. Also, an interesting point is that YouTube videos, when you embed a YouTube video or a Vimeo for that matter, you're not actually copying it, you're copying the link. So it's perfectly okay to embed YouTube videos in your courses. I would say that if you want to be really strict about copyright, you probably want to make sure that that video was legally posted on the web. In other words, if you're posting a BBC TV series links, you probably want to make sure it's posted by BBC and not by Michael Rodriguez, because I may not have permission to post it. But that said, linking has traditionally been upheld by the courts as perfectly acceptable, even if the content that you're linking to is a bit on the copyright squiffy side. I hope somebody gets the Battlestar Galactica illusion here. If not, I found it was a humorous image. Ah, excellent. Aha. Luli got the illusion, so did Zada. Excellent. Amanda. Hmm. Yeah, porcupines are awesome. So Section 108. This is an actual exception in the U.S. legal code, federally, for libraries and archives. And it gets really specific. So any library or archive can make and distribute one copy of any work as long as the library is A, open to the public, and B, there's no commercial advantage to be obtained. And more importantly, libraries can make up to 3 copies of unpublished works for deposit in their collections if the work is not otherwise available in digital formats. And this is essentially what archives do all the time. They take print works, old photographs that no one else has on the web, and they scan them, digitize them, put metadata on them, and upload them to a digital repository. Another exception is that libraries can make 3 copies of a published work if the format is obsolete. So if there's no machine that is on the market, readily available on the market, that can be used to read the work. Technically, VHS and floppy disks do not count as obsolete formats. There's still old computers and VHS players that you can buy on eBay and whatnot that will read those works. The other criteria, you can make 3 copies of a published work if the item is damaged or lost or stolen or is deteriorating. and if a replacement can't be found at a fair price after a reasonable search. Um, so theoretically, if you have an incredibly old, I guess if you have an old piece of music that's still under copyright, um, but but is deteriorating, and you can't find, and the only replacement copy you can find is on eBay for $1,000, you would be able to make 3 copies of that work. However, you have to limit public access to those copies. People have to actually physically be in the library in order to have access to those to copies of published copyrighted works. So Section 108 is fascinating, and if you're interested, I would Google it and give it a read through. It really is quite compelling. Yeah, I wouldn't be surprised the video game industry is fighting that, Justin. I was actually reading a book on video game history the other day, and it was truly fascinating the ways in which games built on each other, and the ways in which game producers struggled to limit independent developer access to the to the programming behind the games. No, it's actually a new book, Amanda. Ultimate Video Game History. Cool. It's brief history of video games. Hasn't been published yet, but it'll be reviewed in Library Journal. It's a really cool book. Ultimate Video Game History. I will have to file that. I'll have to file that title away for future reference. One other thing I should add is that Section 108 typically applies to textual works. So if you're talking music or films or images, um, you have to be a little more critical of the process you're going through, especially if the music, film, or image was published and under copyright. And let me just type out the title and author for you, Amanda. Brief History of Video Games, Richard Stanton. So interlibrary loans. This is permitted under Section 108. Again, though, and I forget who raised this in the chat box earlier, ebooks are not covered by interlibrary loans. And oftentimes you can only pull one journal article per issue, that kind of thing, for a given patron. So there are a lot of restrictions on interlibrary loans, and the problem with ebooks really has to be resolved sooner rather than later in order for libraries to continue providing effective service to our patrons. Copies. Section 108 frees libraries from liability for unsupervised, and I want to put that in quotation marks, unsupervised use of library photocopiers or other recording equipment that results in copyright infringement. So if a user comes in and goes to an unsupervised photocopier and proceeds to copy an entire textbook, if we don't know about it, then we are not liable for it. Now, if the person comes up to us and asks us, hey, can you copy this book for me? Or I want to copy this entire book. Can you show me how? Then we're entering infringement territory. The key thing to add here is that your photocopier really needs to have a copyright notice posted. And the verbiage is provided in, awesome, that's good, Justin. And the verbiage has to be provided as a sign or on the screen of the copy machine. And the verbiage is provided by the government. The making of a copy may be subject to copyright law. You don't need a super fancy disclaimer. You just need to notify users of the machine that what they're doing may be subjected to copyright law. Not that they'll know what that means. But really, as long as you aren't monitoring the printers and the copy machine, you're safe. Ignorance is bliss, especially in public libraries sometimes. Of course, Section 108 applies to archives and special collections, and not just libraries. I love this picture, by the way. Um, Archives usually come with their own sets of copyright concerns. So orphan works are a big issue. Digitization is always a complicated process because you have to assess what is under copyright, whether other people have digitized it, and so on and so forth. And I'd definitely be happy to talk to you about that. But I think that my colleague Justin White here may put in a comment would also be a good one to have a conversation with. Ebooks. Yes. And put that in all caps. Ebooks. Do we own ebooks? Yes or no? You can put it in the chat box if you like. A Y or an N. Mm-hmm. Mm-hmm. I like these responses. Exactly. Exactly. That is a really nice summary, Chandra. Mm-hmm. I'm actually going to be talking about John Deere tractors soon, Justin. Um, Actually, you don't own ebooks. You licensed them according to the terms of whatever agreement or contract you signed when you downloaded the ebook or when you signed that contract with Overdrive or eBrary or Amazon Kindle or whichever company you're using. And this is shocking to most people because you pay good money for ebooks. I mean, why don't I own it? Why can't I put it on as many devices as I want? Why can't I? Why can't I print it out? Why can't I loan the ebook to my friend? Um, why do I have to pay for a certain number of uses? So, example, in pretty recently, just a couple years ago, I think, Amazon actually deleted an ebook from hundreds of Kindles without notice because it turned out that the publisher of the ebook didn't have the right to distribute the ebook via Amazon, didn't have the right to sell it through Amazon, wasn't the publisher. The problem is that Amazon did not notify or compensate people who bought the ebook, and the ebook just vanished from their Kindles one day, and they didn't hear a peep from Amazon about it. So Amazon was fulfilling its copyright obligations, granted, and in the terms of agreement that you accepted, you probably agree that Amazon can come into your Kindle and make modifications to your ebook collection. The irony is that the ebook that was deleted was George Orwell's 1984. I thought that was a I thought that was a rather beautiful touch. And of course, the other issue too is proprietary formats. I mean, Amazon Kindle is a proprietary format. It's not really cross-compatible with with EPUB or with other systems. So if Amazon goes bankrupt or decides to change their unlikely or decides to change their format of the ebooks, who knows if the Kindle books you bought will still be accessible. Also, if you potentially, I mean, if an ebook vendor a library contracts with goes bankrupt, I mean, we could lose access to that ebook collection that we paid for. Also, it's a pricing problem. Publishers set the price for libraries to loan ebooks typically for a given number of times or a given number of years before you have to repurchase the right to loan out that ebook to patrons. Or, and we're talking audiobooks here too. ILL is pretty much impossible because the rules governing digital books are quite different from rules governing print books. Print books are governed by the first sale doctrine. You buy it, you own it. Ebooks, you license it, you don't own it. And they're often more costly than print books. I remember Sheryl Sandberg's book Lean In, published a couple years ago. If as an individual you buy the ebook, it costs you $12.99. If as a library you license the ebook, it costs you $74.85. So oftentimes ebooks are, as the e-resources librarian, I handle our demand-driven acquisitions contract, and I was kind of flabbergasted to see that loaning an ebook to a student for one day is sometimes more expensive than actually buying the print book, which was pretty shocking. And that's definitely that DDA process has definitely been revised. And the same applies, as Justin says, to iPods, to music, and to digital movies. And also, another point, I mean, you cannot transfer ebook rights as an individual or as a library. So individual customers cannot donate ebooks to libraries the way they can print books. And Justin, you're exactly right. The central issue there is DMCA, the Digital Millennium Copyright Act. And this essentially criminalizes since 1998, it criminalizes producing or disseminating devices or software meant to circumvent technological controls that limit access to copyrighted works. So, in other words, you can't unlock your ebook without breaking the law. You cannot convert a Kindle ebook into an open source EPUB format without breaking the law, for example. So this doesn't just ban pirated software or illegal downloads. This bans changing the settings on the computer in your car that drives your car, that regulates your AC and your engine. It bans reverse engineering a computer program just to see how it works. It doesn't matter whether the circumvention itself results in breach of copyright, so fair use doesn't even apply necessarily. Um, and for a while, up until 2013, you couldn't even circumvent controls that prevented the use of a screen reader on ebook readers that didn't have a built-in capacity to use screen readers. The DMCA also requires YouTube and Google to remove search results that violate copyright. Someone just has to send them a takedown notice. Um, so one of the big issues with digital rights management and the DMCA is that you don't really own the software that is fundamental to how we live our lives. Service manuals are copyrighted. Diagnostic tools are often proprietary software. There's actually a lawsuit going on now in which John Deere, the manufacturer of this tractor, is claiming that the farmers don't actually own the tractor because they licensed the software that enables the tractor to run. So licensing is a really big, hairy issue in librarianship as well as in the general world. And it's going to be really interesting to see what happens with that. So e-reserves are another big issue for academic libraries, especially. When one puts articles and books and so on electronic reserve for students, you you have to comply with the Teach Act, and you have to conduct fair use analyses, and you have to be careful what you put on reserve and how much of it you put on reserve and who can access it and so on. And universities have been sued by publishers big time for this, even though the courts so far have mostly sided with the universities. So this is e-reserves are an issue that will have to be worked out. And also going back to what I mentioned earlier about digitizing ebooks and the problems associated with that. So Authors Guild sued the HathiTrust Digital Library, which is an academic library consortium, because HathiTrust was digitizing print books in order to build a full-text searchable database. So anyone on the web could go in and search the full text of all these books without actually reading the books themselves or having access to the books. The Second Circuit Court of Appeals is pretty awesome. They are really good at upholding copyright on the user side of things, and they said that this is fair use, that this is transformative use, and that yes, HathiTrust also has the right to make text available in formats accessible to print disabled people if the publishers aren't doing a good job. No, actually, Amanda, Google started digitizing books before HathiTrust, and Google essentially decided there was a huge lawsuit, years of haggling, and eventually Google decided that Google Books is just not worth pushing the envelope on. And so HathiTrust and Internet Archive and others have taken up the banner of making ebooks more accessible to people. Yes, Justin, Google Images thumbnails are transformative for the same reason that HathiTrust full text searches are. It's a transformative use. It's taking the original content completely out of context and changing how it's used and accessed. Oh boy, videos, music, and public performances. So videos, you generally do have to purchase public performance rights in order to screen a film outside the home or the classroom. We talked about Netflix a minute ago. So this makes it really hard. I'm the e-learning librarian, so I struggle with this, to distribute digital videos to classes online. Um, Typically, you have to pay a vendor who takes care of all the licensing for you, and then you can link out to that vendor's website. That gets pricey, needless to say. And the same goes for music. I mean, music is subject to heavy restrictions. Rule of thumb historically is that you can use up to 30 seconds of a song in a video or a pastiche that you yourself create. That's probably too much, though. 30 seconds really is probably too much. And you really have to apply the fair use test to verify that you're not going to impact the market value of the song and that that you're using it for educational purposes or critiquing it and so on and so forth. So you have to be really careful with videos and music because oftentimes those are the things that publishers jump the hardest on. But that said, there's a lot of open resources out there. Creative Commons is amazing, truly amazing. So in Creative Commons, it's a movement and it's also an open licensing system. So what you can do is release your work under an open license. So anybody can take the work and use it, modify it, share it according to the terms that you can specify. So you can release your work to the world, your photograph, your article, whatever, under a Creative Commons attribution license. So anybody can do whatever they want with your work as long as they give you credit for producing that original work. You can release it under a no derivatives license. So people can share the work freely, but they can't modify it. Or release it under a non-commercial license. So anybody can do anything with the work except use it for financial gain. And all of these licensing licenses can be put together in various ways. You don't have to select just one. You can select all of them if you want. So there are tons of resources out there for open images, and this is particularly important for libraries with social media and with displays, because images do fall under copyright, and you can be sued or get a cease and desist order if you start using copyrighted images willy-nilly on social media. Flickr Creative Commons is awesome. There are hundreds of millions of photos, well, millions of photos in these repositories. Flickr Creative Commons, Wikimedia Commons, Pixabay, OpenClipArt, which is all the more important now that Microsoft has discontinued the clipart function built into Word. And also Creative Commons. If you just go to creativecommons.org, you'll find a nice unified search box that enables you to browse most of these sites and find images that suit your needs. And this is what I did for my own slideshow today. As you can see, the image here is courtesy of Biblioteca de Arte in Brazil. And I just put a YILA citation down at the bottom. It's Creative Commons licensed. So I can feel free to use it as long as I cite it and as long as I use it according to the terms of the license here. You can also do Google image search and limit to Creative Commons, but that's not as reliable. I would prefer going to Flickr or a Creative Commons specific site. Open reads. This is pretty important if you're an academic library or a public library that may not have access to a lot of academic databases. So these are hundreds and thousands of books and journal articles and audiobooks and so on that you can access for free on the open web. And again, these slides will be posted on Swiftlin's site, so you don't have to frantically jot down the names of everything. Directory of Open Access Journals is pretty amazing, by the way. And you can integrate it into your WorldCat discovery layer, so patrons can find it without having to go outside the library. It's a really nice resource. And Open Library is a project of the Internet Archive. And what they do is actually license current ebooks, like currently copyrighted ebooks, and individual users can download them and read them. And I have no idea how that works, but it is quite a remarkable service, and apparently it's fully in line with copyright regulations. So also open educational resources. This is cool for the teachers and instruction librarians who might be in the audience. These are all Creative Commons licensed resources. So we're talking videos, syllabi, entire courses, assignments, learning outcomes, the whole bit that you can use freely in your own courses and your own instruction. Open Educational Resources Commons is fantastic. Khan Academy has amazing instructional videos on all kinds of topics, everything from statistics to computing. Khan Academy does rock, Amanda. Yes, indeed. And this is what I think is key to the future of copyright. I love this little cartoon. It's a picture of the copyright guy, Achilles, I guess, running a spear through the heart of the public domain. Remember, the public domain has been steadily encroached in these last few years. Copyright terms keep being extended. Works that should be entering the public domain are not. Let me give an example of the Mickey Mouse Protection Act, as it's nicknamed, of 1998, which pushed back copyright, extended copyright from life of the author plus 50 years to life of the author plus 70 years. So adding 20 more years to copyright. And this was pushed very strongly by Disney because a lot of Disney's early films like Pinocchio and Snow White were about to enter the public domain. And Disney did not want to lose the profits garnered as a result of perpetuating copyright over those old films. So copyright is corporate capitalism here. Let's just say companies, publishers, folks with interests, with financial interests in maintaining copyright, is undermining public domain, and yet open access and open source and all these free repositories and collections that we're looking at are the Achilles heel of overly restrictive copyright. And this is kind of what I wanted to talk about to end with, because as librarians, our job is not only to fulfill our legal obligations, but also to make sure that our patrons get access to information, that everyone gets access to information, ultimately. And we can't necessarily do our job as well if there are a million copyright regulations in the way. Oh, hey, no problem, Nancy. And Nancy Hicks, definitely, we need to achieve that balance. Right now, copyright is pushing way too much toward restrictions. My hope is that open culture is going to put pressure on this overly restrictive copyright, and so we can start gravitating back toward a more balanced center, the way the system had worked for 200 years prior to the Copyright Act of 1978. So the so what factor in all of this is absolutely protect against lawsuits, avoid cease and desist orders, safeguard your teachers, your principals, your users, your colleagues. But I think that by using open culture, open sources, open access images, and so on, we can actually create better, more original displays, more engaging social media. We can strengthen our libraries and open culture in relation to the company profit motive that is restricting access more and more. So, what can you do when you get back to the office? When you hit the X in the corner of Adobe Connect? Whenever you encounter a copyright scenario, you can do a mental fair use analysis. It doesn't have to be super formal, but you have to be able to keep the fair use criteria in mind and apply it accordingly. And I'm actually going to put a link in the chat box to a really awesome fair use checklist put out by Columbia University. You can also ask for permission to use images and to post articles and ebooks. Even if you don't get permission, even if you're ignored, you can still potentially use that image as long as it matches fair use. So it really doesn't hurt at all if you ask the publisher or the author. You can train your colleagues. You can link out instead of downloading and uploading files. And you can use open licensed and public domain resources instead of rigorously copyrighted resources. So you can apply what you know and create more, be more creative, be more innovative, and not have to use Microsoft Clipart anymore. I had to throw that in there. And you can share your knowledge. A lot of faculty kind of know about copyright, but don't know how to comply with it. So copyright is a fantastic opportunity for faculty outreach, for outreach to teachers and to principals. You can hold seminars on copyright. You can become the campus go-to specialists on copyright. Also, you need to know your copyrights. Don't just know your obligations, know your rights, as the awesome Joe Strummer of The Clash would say. So you have to take copyright seriously, it's important, but you do have to know what you can get away with and what counts as reasonable fair use. And here are some resources for you to check out later when the PowerPoint and PDF are posted to Swiftlin's site. There's some really awesome resources here on Creative Commons images and specific links out to government and university sites that will help you. Oh, absolutely, Chandra. Yes, you may indeed link out. And in fact, I saved the best for last. This PowerPoint today is licensed under a Creative Commons Attribution Share-alike international license, Creative Commons. So as long as you give me attribution, and as long as you don't force people to pay for access to this, you can feel free to distribute this to your students, to your faculty, and to your colleagues. And again, if you can link to it, that's awesome. But if you want to download it and play with it, you're within your rights to do that as well. So thank you so much, everyone. I really hope this was helpful, and I would love to take any questions that you might have. Okay, so Nancy, you're interested in interlibrary loan. And yeah, I know I skimmed over that pretty quickly. So really, you can't interlibrary loan ebooks. We know that. And the restrictions on videos and so on are fairly limited as well. So that is actually not a primary area of expertise for me, but I would be more than happy to exchange emails with you. My email is right up at the top corner here, and we can look into copyright issues regarding journal articles. I know in the past, librarians who were previously affiliated with institutions, um, like they studied at Florida State University or USF, oftentimes they will end up copying. They will go to that site when there's interlibrary loan at their current institution. They will go to their previous institution's site, which may have more access, and download the PDF files and then share them with the patron, which you're not really supposed to do. So that is one caveat that I will definitely put on the interlibrary loaning of journal articles. ILL should go through the formal process as laid down by the federal government and so on. Oh, thank you very much, Marilyn. I appreciate that. I hope my use of images was engaging. And let me actually flip on my webcam again, since we're 4 minutes from the close of session. Are there any other questions? I see a couple of people are typing. Oh, thank you, Nancy. I appreciate that. Usually I go with the plain white backgrounds, but I decided to get really fancy for this presentation, and I'm glad it's been well received. Oh, thanks, Amanda. Yeah, and absolutely. I mean, don't be strangers, guys. If you have any questions at all, shoot me an email, connect with me on LinkedIn or Twitter, and even if I don't know the answer to your question right offhand, I will be more than happy to work through any copyright scenario with you. And if you want me to come by your institution to talk to anybody or to give this presentation, I'll be more than happy to do that as well.
I can answer Angela's question about musical scores. You're technically not allowed to. That does go against copyright. If you're using it for your own personal use and no one else uses it, then that's fine. But if you were to, say, have a class of music and you purchase one score and copy it for your entire class, that goes against copyright. You'd have to get explicit instructions, permission from the creator.
Yes, musical scores, pretty much everything to do with music and videos is so much more, well, not so much more, but is more strictly regulated oftentimes than purely textual items. Probably because there's more of a, again, unique creative work, more of a profit motive, etc. Aaron is our opera guru, so he's definitely the one to ask if you have questions about music and copyright. Oh, Kathleen, you can just shoot me an email and I'll be happy to set up a date to come by whenever. Um, I may or may not charge. Probably not. I believe in open culture after all.
Michael's actually a local, Kathleen. He works in Collier, so he has a possibility for presentations through Swiftlin if there is an interest and a need, if he doesn't want to do it by himself.
Oh, that's hilarious, Nancy. No, I'm actually not that tall. I'm only 5'7". But top shelver because I got my start in the Collier County Public Library system as a library assistant, and I had a reputation for shelving, let's see, I believe it was 220 books per hour, which it was apparently exceptional. So somehow I got that name and it stuck, and now it's my social media. It's my social media brand. Yes, Amanda, I think so. You'd have to double check with Aaron, but I'm pretty sure the entire presentation, audio included, will be on Swiflin's website.
We record all our presentations, and so you will get a link for the entire recording We also PDF the slides for them to be handy. That's how we deal with it. So if you were to send a link for the recording, people can see the presentation that way. Or if Michael wants and is allowing us, I'll put a link for an actual presentation of the entirety. It'll be a Google Doc PowerPoint like he gave to us, if he's letting you use his presentation, as long as you attribute to it.
Link out indeed, Amanda.
All
Oh,
right.
it
Well,
was my pleasure, Susan. Thank you for coming.
it's 11:31, so I'm going to just close it out real fast, and you guys can stay on and ask more questions or give more accolades towards him. So thank you, Michael, for a wonderful webinar. We're very lucky to have been able to participate in this learning opportunity. Great information, sneak peek of what's to come. Attendees, on May 8th, we have the 7th of our webinar series on diversity. May 8th webinar is I for Inclusivity in the Workplace Culture. Also coming up next month, we have a workshop on cataloging troublesome stuff. That is May 22nd, and that's presented by Dr. Karen Snow. So if you're into cataloging, we suggest you sign up. Also, on May 29th is our Patron-Driven Acquisition webinar, Part 2, Who Gets to Choose, with Dr. Naomi Gold. And for those of you who are signed up for Library Staff Day, that will be next week on May 6th, and we look forward to seeing everybody. And I'll turn it back over to Michael if you'd like to talk more.
Always happy to.